Hello, everyone. I hope you're enjoying the Business Revolution week so far. We're very excited to be bringing this special event to you, and we thank you for your attendance. My name is John Hannon, and I'm an analyst with Culkin Ginsberg. I wanted to run through a few housekeeping items before we jump into the informative roundtable that we've got for you. First, I want to thank our wonderful sponsors and subject matter experts for their continued support. Without them, none of this would be possible, so we're very thankful to them. Second, I'd like to give a disclaimer. The information that you're about to hear in this roundtable discussion is not intended as legal, financial, or advice of any kind, and it may not be used as such. Advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure that this information is up to date as of the date of this roundtable. It is not intended to be a full and exhaustive explanation, nor may you use this information to replace the advice of your own legal counsel. The speakers assume no liability for any verbal mistakes or other errors contained in this roundtable, or for changes that occur in the future that affect anything that's discussed therein. So without further ado, I'm going to hand it over to Mike, and we'll jump right into this informative roundtable. Thank you.
Hello, this is Mike Ginsberg, President and CEO of Culkin Ginsberg. We're delighted that you took some time out of your busy schedules to join us today. This past Friday, the CFPB released their final rule on debt collection. So that means our astute and esteemed subject matter experts spent Halloween weekend eating a lot of candy and watching movies, right? Seriously, we put together this dream team of subject matter experts to interpret how Regulation F will change the scope of collections. We're going to look at it from a variety of points of view, we say it in better English, and together we're going to discuss specific topics such as safe harbors, contact frequency limitations, new rules, and other pertinent topics. First, let me take a moment and introduce our subject matter experts. Leading off is Roseanne Anderson. I will say that Roseanne is not only a subject matter expert, but she is going to serve as ringmaster, moderator, and just keeping us all on point here. Roseanne serves as Ontario Systems Vice President and Chief Compliance Officer. She's responsible for leading Ontario Systems corporate efforts and response to the CFPB's launch of compliance examinations in the arm industry. Her advocacy work on behalf of credit and collection professionals in the industry at large has resulted in landmark legislation and regulation at both state level and at the federal level with regard to the alphabet soup that we all deal with, FDCPA, FCRA, and of course HIPAA. In 2020, Roseanne was named Chief Compliance Officer of the Year for large companies by the International Women in Compliance Network. Roseanne, good morning. Thanks for joining us.
Good morning, Mike. Thank you. Glad to be here.
Keeping up with ladies first, Joanne Needleman is next. Joanne leads her firm, Clark Hill's Consumer Financial Services Regulatory and Compliance Group, serving as a navigator to our clients who are seeking advice and guidance in the complex regulatory environment facing the financial services industry. She provides counsel, consultation, litigation services to a wide array of financial institutions, law firms, credit reporting agencies, collection agencies, various other service firms, as well as venture capitalist firms looking to invest in the fintech space. A former member of the Consumer Financial Protection Bureau's Consumer Advisory Board, Joanne has been able to provide her clients with useful strategies in order to prepare for new areas of regulatory scrutiny. Joanne, good morning. Thanks for joining us.
Good morning, Mike. I'm very happy to be here.
Tom, you're going to go last because Stephanie is next.
Stephanie I would have predicted that.
Leader of Ballard Star's debt collection team and partner within the Consumer Financial Services Group. In addition, Ms. Jackman is a partner member of the firm's fair lending, blockchain technology, and cryptocurrency. Try and say that word 10 times fast. Cryptocurrency teams. She devotes her practice to assisting financial services institutions facing state as well as federal government investigations and examinations, counseling them on complex issues, as well as defending them in individual as well as class action lawsuits. Stephanie, good morning. Thanks for joining us.
Thanks for having me. Good morning.
And last but not least, our number 4 batter, means he's going to hit it out of the park, is Tom Good, the managing attorney of Barron and Newberger PC. He works in the firm's Consumer Financial Services Law Practices Group and practices out of their Denver office. With over 30 years of experience in business and regulatory matters, Tom Good has served as general counsel of 2 of the nation's largest debt buyers, taking one through a public stock offering and the other through a bond offering. Working with the firm's Consumer Financial Services Practices Law Group, Services Law Practice Group, he provides outside general counsel services, compliance advice, other assistance with mergers and acquisitions, and his clients include, but certainly are not limited to, financial institutions, debt buyers, collection agencies, and law firms. Tom, good morning. Thanks for joining us.
Pleasure to be here.
Roseanne, I'm going to turn the keys of the bus over to you. We have a lot of topics to discuss here. Maybe you want to kick it off in a particular way that kind of captures the group here. So maybe at a high level, I'll turn it over to you, and I'm here to assist as needed. Thank you.
Great. Thank you, Mike. Thank you, Cock and Ginsberg. Thank you, panelists. So let's dive into this. I thought one way to help our audience kind of level set with us is to talk a little bit, very briefly, a couple of you just chime in. What was your observation about the comparison between the proposed rules that we saw in May of 19 to these final rules that we saw on Friday, October 30th? Any one of you want to comment initially on that one?
I'll start, Roseanne. I was really surprised how different it was. We had spent the last, many of us, definitely Stephanie and Roseanne, we did the webinar circuit back in May and, painstakingly went through every line, paragraph, and sentence of the NPR. And we all kind of felt, as we were collaborating before October 30th, that, we didn't think there was going to be wholesale changes. Maybe there wasn't wholesale changes, but the way it was described is completely different than what we had anticipated. And Roseanne, you made a good comment on the numerous other previous webinars that we have been on together, that, we had been talking with our clients and setting up processes and procedures based on the language and the wording of the NPR. Mm-hmm. None of what we see in this rule has been vetted. We didn't think about doing it going from A to B in the way that the CFPB did it. Now, is that good or bad? I mean, is that process better or worse? I'm still trying to figure it out. I haven't made any conclusions yet, but that was my biggest, it was like, wow, I got to read this thing all over again.
Yes, all 650 some pages.
I thought it was going to be easy because I was cutting and pasting and I was like, oh no, my weekend is ruined. So
I know.
That was my biggest shock.
I completely echo that, Joanne. I really thought and had been predicting there wouldn't be many significant changes. And when you first look at the rule, it might seem like, well, it didn't change much. But when you start to dig in, there are a lot of shifts and changed approaches that actually interject some really unique and candidly new considerations. And I know we'll talk about that more, but for instance, this idea that now we have a rebuttable presumption on call attempt limits as opposed to a hard line. But that rebuttable presumption goes both ways, and it can open up some avenues for things that aren't subject to those limits, other types of communication channels like text and email, still factoring into whether or not a consumer might be able to rebut the presumption that even fewer than 7 attempts when looked at holistically within your contact strategy is problematic. So like, I did not see that coming. And I'm, to Joanne, I'm still sussing out what my reaction is, but I'm not entirely sure that I think that's actually a positive thing. Yeah. But it is. It kind of makes me think back to the, as Joanne said, at the May circuit back in 2019 when the NPRM came out, and it's like, why did we make all that effort?
Right.
That's really good. Tom, what do you think about that?
Well, it's kind of funny. One of my major disappointments with this, and by and large, I'm pleased with where it came out. But having to wait till December for the validation notice,
Right.
it's like that was really going to be a critical change for a lot of people, and now we're just sitting and waiting. And so that was a little disappointing. To pick up on what Stephanie was saying, I think that, you know, having a rebuttable presumption is something that's going to be drive the lawyers nuts trying to figure it out. I think probably by the end of the day, what people are going to wind up saying is, as an operational matter, as a training matter, it doesn't matter whether it's a rebuttable presumption or not. You're going to stick with this limit. And just
You know, I always put myself in the shoes of the audience, and the off chance they do not really understand a safe harbor versus a rebuttable presumption.
Mhm.
Do any one of you want to just do a real quick explanation? Otherwise I can, because sometimes that's become common. It's a typical conversation that we have with one another. I don't know if the marketplace has the same reaction. Who wants to do that? Rebuttable presumption
Let's put it
versus.
this way. How much do you want to spend to defend?
Yeah, absolutely.
Because if you don't want to spend a lot of money to defend, then you comply with the safe harbor. If the safe harbor tells you to do X, then do X and move on. You might not like it, but just do it.
Right.
But if you want it, you know, if you like to go to Vegas and you like to play, you know, the tables or whatever, and you want to roll the dice, then you do the rebuttable presumption, because that means that if you go over whatever limit, in this case, the call frequency limit, you're going to have to then come forward, spend a lot of time and money saying why you did it, and then cross your fingers that a court will agree, or there's other evidence that may come in against you that would disagree it. So it's really a cost benefit analysis, in my opinion.
It is, except that the way I read it, we had a safe harbor from May until Friday. With
Correct.
some of these call caps. And then that's where we saw a substitution of the safe harbor, you know, at least if I do that, I'm okay. To
Right.
now, you're probably okay, but you're going to have to prove that the 7 call caps in your situation based on this consumer was in fact not harassment, abuse, right? Isn't that the way this will fall down or go?
It is. And I'll tell you what also concerns me, and this is kind of sprinkled throughout all the comments and the analysis and even in the official interpretation, the CFPB also left the door open, and they say it several times, that even now, before, you're right, Roseanne, before October 30th, it was either you're in the harbor or you're out of the harbor.
Right.
Now they've said not only are you can have a rebuttable presumption if you go over, but we're also going to look at what you do when you stay within the harbor. So
Yes.
you might not violate, you might not be acting in an harassing or abusive or deceptive way. But even if, say, with emails, you're sending successive emails, we're still going to look at that to see that you
Right.
still comply with other sections of the FDCPA. And they didn't
Right.
talk about that before. And that's what really, to me, opens the
Right.
door, and my concerns with a lot of the language of the final rule.
I agree.
I think what they're trying to do is they're trying to incent people. And if I was a compliance officer at a firm or a operations manager, they're trying to incent you to really stay conservative. Don't go right up to the line and think you're safe, because you may inadvertently step over the line. And if, as a firm, you have a philosophy of, I want to be within the letter and the spirit of the rule, you'll be okay. But if you want to take it to the edge, you're going to wind up in trouble. For instance, one of their comments made the point that, you know, you have a 7 call limitation. What if you spin the call 7 times in an afternoon, you know, trying to get the person? Then you're probably in trouble, even if you don't violate the raw number.
Right.
It feels oppressive.
Right. Stephanie, do you want to talk a little bit about the call caps, the attempts to call? I think one thing that I would like our audience to appreciate, that there are 3 important references. You need to understand what a contact is, you need to understand what a communication is, and you need to understand what is an attempt to communicate. Stephanie, I'm sure you agree. Do you want to kind of try to wrestle with those for our audience and tell us how the rule came down on that one?
Yeah, I'll certainly do my best and invite the other panelists to fill in what I'll inevitably miss. So first of all, it's important because I've gotten some questions about this. It's important to understand that the 7 call attempts within a 7-day window only applies to call attempts. You do not need to count emails or texts for purposes of the call attempt frequency limitations. That was one thing. I've had some people say, are those included? Do they really mean that? I suspect it's because sometimes you see, especially with state laws or loose language in cases, communication, which is broader than a call. This is calls. However, a limited content message counts as a call attempt for purposes of the frequency, that and at the 7 call frequency limit. And that's important because what the limited content message, and I don't want to jump too much into that right now, but just as a flag, and we can come back to in a minute if we want, it is categorically not a collections communication. That's the whole point of it, to minimize third-party disclosures. So it's important to realize, because you could immediately, if you're used to dealing with the FDCPA, say if it's not a collection communication, it's not subject to the FDCPA, right? Wrong. For at least this provision, it counts for the 7 calls. So do voicemails.
As well does a voicemail. Yep.
Yes, ma'am. So do voicemails that are left with the consumer, including ringless voicemails, if you utilize any of those technologies that will send a message without ringing the phone. What does not count? Calls that do not connect. I'm still trying to suss out, and I'd welcome any thoughts on if a third party answers at a number that belongs to the consumers. We're not talking about a location call, but location calls are also subject to the limits. So if you're trying to reach somebody, you need to be calculating the same frequencies.
Well, let's keep that.
Yep. And then going back to so once you have a right party contact with the consumer, and this is a big change from the NPRM, because the NPRM was proposing or leave a substantive message. And I don't see that here. I see a live connect with the consumer. You then have a 7-day waiting period before you can place additional call attempts, not communications, call attempts. So Roseanne, let me stop there because I know there's a lot, and see if there's anything you want me or others to kind of dig down into or cover as we move forward.
Well, I'm going to turn this over to Tom for a second, but I just wanted to make sure that when some people read state law requirements regarding collections, they use a word like contact, C-O-N-T-A-C-T. And that's a very nebulous term. Looking at the analysis within the FDCPA, I just wanted people to remember, and you explained it, a communication under the FDCPA is a defined term. And when you are engaged in a communication, certain disclosures are triggered. If you're not in a communication, for example, if you're attempting to communicate, the way I understand it, now that kind of takes you away from the disclosures, but not the FDCPA. So anyway, Tom, any comments on all this?
Well,
Spaghetti.
yeah, it's a bit of it'll be a bit of a challenge in terms of how we implement things. I think that, you know, once again, if you stay conservative and well within the boundaries, if you treat, you know, the hypothetical of, you know, isn't a communication or an attempt, and somebody picks up the phone, but it's not the debtor, I think you got to count that as one. You just have to, because otherwise you're going to inadvertently go over the limit.
Well, it was an attempt, right? Did you count it?
I absolutely think it was an attempt. You know, so once again, what you're trying to do is you're trying to stay, obviously this business is about communicating and about attempting to communicate, but you don't want to push it right to the line, right? Because you are going to inadvertently go over. I also think the problem is going to be, you know, sometimes regulators think that you have one account that you're working and that you can physically keep count of how many attempts you've made. I would wonder how your system is going to handle this sort of limitation, and whether you're going to need to, you know, reprogram your system, how you're going to handle it from a dialer campaign perspective, because you're not going to be able to count on your collectors to manage this. It's got to be.
No. Joanne, I'm going to turn this over to you in a second about reasonable procedures in terms of capturing some of this data, such as a permissible email address or permissible mobile number. But I did want to say before we leave this, attempt to call versus actual communications. One of the strange requirements, I think, is that they said, once you actually have a conversation with a consumer, then you must wait 7 days to have another conversation or whatever with that consumer. I suppose that rules out attempts to call during that period because there would be no point, but you have to wait. And they didn't define, they did say this, they said, use the day of the conversation as the first day in the 7-day period. What they didn't do is explain what on earth is a conversation. Like, I feel like we are having a conversation.
Right.
You know, somebody called me and I said, are you kidding me?
Well, as I see it, if I was helping somebody to kind of implement right now, where I agree with you, there's a lot of ambiguity, and we're trying to minimize how much we will be a part of the inevitable litigation that tries to define and refine it. I would take the position that a communication, and to your point, Roseanne, drawing on definitions that already exist under the FDCPA and commentary in the rule and statements in the preamble that make it clear they're really thinking about a live connection that results from an outbound call effort, is what they mean is prohibited in that 7-day waiting period. If a consumer calls you, the rule expressly allows you, notwithstanding that it could result in 8 attempts or during the waiting period, to return that call. But interestingly, so long as you do so within 7 days of the consumer giving that consent. I think operationally that probably will often be the case, but not, I mean, if your volumes get really big, if we have another pandemic impact that disrupts your business, that's something to be mindful of, because you don't get to do it 10 days later and maybe you're in another waiting period. So that's just something to be aware of. But also, I think that, I just lost my train of thought, but I take it narrow. So the other thing is, if it results from your text or email communication you send out, it's categorically not counted, and the consumer responds either by phone or text or email, I would also take the position that there's enough support to make a good argument. That's not what the Bureau intended either. They want to facilitate communication and helping consumers resolve debts, but they want to limit the opportunity to have that occur in a way that they have determined is intrusive, i.e. phone ringing.
Okay, very helpful. Joanne, let's turn a little bit to, I guess, the meat of an email. You need to have an address. So too with a text, you need to have a mobile number. Do you want to talk about those 2 sets of requirements?
Yeah, so I think one thing I think the Bureau did well was to kind of break down the idea that, okay, we can communicate by email and text. And then they broke it down, and you need to have reasonable procedures in place before you do that to ensure that the email or telephone number for purposes of text are good ones, and you're contacting the consumer. So that's fine. And then they broke it down even further for email, which I thought was extremely helpful. They identified 3 scenarios of how you determine reasonable procedures for email. So the first scenario is with the consumer. Second scenario is with the creditor. Third scenario is from a prior debt collector. And they run through the procedures. I won't get too granular. They run through the procedures of how to do that. I think what's interesting, my takeaway from the email section is, first big takeaway is, and this is something that I think the Bureau has always scratched their head about. We understand, but the Bureau has never wrapped their hands around. Why don't debt collectors and creditors have better relationships, right? Why, they must talk all the time. They must, they're working hand in glove with each other. And this should all be so simple. Never been that way. I mean, look, I'm sure you all have relationships, long-standing relationships with your creditor clients, and that may be the case. But it's not, that is an exception to the general rule.
Right.
And especially with the much larger credit grantors, that's a tough relationship. People change, people leave, processes change, operations change. But I get the sense from from the scenario that the Bureau describes with getting information from a creditor, that they really want you to sit down now and have this conversation that they thought you were having all along.
Right.
And I think it's such a terrible idea. And it may not work with every creditor, but why can't you if you do have a long-standing relationship?
And just at a high level, just to be clear, what we're talking about at this point, remember, it's under the category of email.
Right.
The reasonable procedure for email. And it's also for our listening audience, what you're basically saying is that the creditor needs to, number one, know the name of the debt collector they're going to transfer this debt to.
Correct.
Right? It can't be just, well, whomever.
Right.
You know, and explain that to the consumer, right?
Right.
And
right.
to use an email, transfer the email that the creditor already used.
Right.
Oh, no, it's not a time period, that the creditor used, and then give the consumer 35 days to opt out, something like that.
That
Right?
is correct. That is correct.
So there's like this whole little set of operational requirements of just email. How about text, mobile numbers?
So the text relationship is not, that can't necessarily, I got the sense that there is really no pass-through. And that there has to be it's up to the debt collector to make the determination. And I dare say that use term verify, because I think that's a scary proposition, but it's going to be up to the debt collector. I'll use verify for term of art at this point, that the telephone number is accurate and that, you know, it has been the number has been used before to text the consumer, or the consumer has given consent to text. Now, there is language in both those options where it says that the debt collector, there's an or. The debt collector can go to a complete and accurate database to confirm that number.
Right.
If I leave it to my esteemed panel, please tell me where that database exists, because I have no idea. And I think that's a very scary proposition. And please know there may be companies out there who this is going to give them license to say, oh, I've got the database, hire us. We don't know that yet. And I would stay very far away from that option until we get clarity from the FCC as to what is a complete and accurate database for reassigned number purposes.
Tom, do you want to comment on that? Perfect. Excellent, Joanne. Perfect. Tom, do you want to comment a little bit on that?
Well, I really have more of a question for the panel than a comment, and that is that the email rules in particular kind of contemplate what would be analogous to a goodbye letter when you place accounts with a collection agency. I haven't seen that done in third-party placements all that much, and I'm just kind of scratching my head and wondering, do you really think a creditor is going to do that?
I think it depends.
Yeah, go ahead, Steph. I do, but I'm glass half full, you know. So
I am not glass half full. I'm very pessimistic in general in life, which is unfortunate. I'm working on that. I think it's going to depend on the creditor. I think it's going to be a situational decision that each creditor makes depending on how easy it is for them to implement that, what the timing will be, what the debt collector is willing to agree to in the placement SOW or MSA or whatever about when it's sent, what will be done before you resume communications, what kind of indemnity is or is not requested. So I think it's going to be very situational, Tom, but I don't think, I think there are creditors that would be actually open to that, and it would fit into their model, and they would feel confident enough in their data and prior activities to be willing to engage in that kind of back and forth and sending of that letter, but it certainly won't be universal.
I just want to say one thing about that. When you think about the debt collection industry historically, and when you think about the total number of debt collectors in the industry, it used to be a rule of thumb that the debt collectors, 75% of the debt they collected was healthcare debt. That used to be kind of a general rule of thumb for the majority of debt collectors. Now there's been, since the CFPB has come about, there's been so much contraction and so many acquisitions. I think the world has definitely changed. But my point is this: I can absolutely see, I'm going up to the line and telling our listeners to recommend, if you collect for hospitals, for heaven's sakes, they are obsessed with consumer patient engagement. I mean,
Mhm.
this would be a perfect way for their patients to be engaged, to understand what the heck's going to happen to them. There's a precursor in 501R. I think it's kind of being picked up here, but I consider it an opportunity for engagement. Joanne, any
I
comments?
agree 100. I think it's definitely worth the conversation. It might operationally not work.
Right.
It might not. I think you're going to have a relationship with the creditor, because if they get an opt out, they got to communicate that to you. How's that going to work? But I think it's a great conversation. And I think it builds long-term engagements with your client. If this is something that you want to do, you're going to have to partner with somebody. You can't jump from agency to agency. This is a way to develop a really good long-term relationship. But I think it's a great conversation to have, to explore. I really do.
It's funny because it's kind of a second part to the same question. The Bureau gave you gave agencies who collect older paper, you're collected seconds and thirds and quads, the opportunity to rely on the immediately prior agency in terms of their obtaining of the email. Since you guys are the August panel, let me ask you, would you ever recommend that a debt collector rely on the immediately prior agency?
No, I wouldn't. It's dangerous.
That felt real theoretical to me, because you don't have a contractual relationship. So if they screw up, you can't get an indemnity.
No.
And I think you make a great point, Tom. And I think to add to that is, but for this procedure that the CFPB is putting forth with your relationship with creditors, would you rely on the relationship with the creditor? Because I know that there's a lot of agencies that, the creditor's like, yeah, this is their email address from an application from 1995.
Right.
So I can't rely on that. So,
Right.
I agree with you, Tom. I think you got to have a lot of processes and procedures in place to, if the duty is to verify what an email or text or a telephone number is going to be, there's still a lot of work that agencies have to do to confirm that. And I think this reliance, Tom, you've litigated, and I know Stephanie, many, many cases of, I relied information from a creditor. Are you allowed to do that? Why shouldn't I be allowed to do that? I mean, that is a path that you don't want to go down.
Well, and if I'm the agency that wants to rely on it, and I'm getting a transfer, whether it's coming from the creditor or the prior agency, the creditor said, just send it over there. The first thing I'm going to say to the creditor is, you going to rep and warrant the accuracy of that? Are you going to indemnify me? Because Tom, you make a perfect point. I don't see agency one being willing to be engaged in that way when the accounts are removed from them and put somewhere else who's probably a competitor and being willing to pay for their risk.
Right.
And creditors are unlikely to agree to that either, at least in my view.
We're going to talk a little bit about validation notices and some very important timeline information in a second. But before we move to that, let's continue just a wee bit on this topic of consumer engagement. In particular, in the new rules, the final rules as proposed, very nice. In the final rules, we see that the consumer is given an awful lot of power with regard to dictating time, place, and manner of communication. I think we're going to go to all three of you on this one, but I'll start with Joanne. Any comments about that? I think the audience needs to understand this is a real weird one, in my opinion.
Well, look, the statute has always said that you can, there are certain times, it talks about place, but the statute doesn't really dive into what place means. But, you can only contact a consumer between 8 a.m. and 9 p.m. My numbers might be off, but, they've always given you a time frame of when to contact, but they really focus on place here, which is so weird because there is really, we all have cell phones, we don't use our landline. So place means nothing, places I'm in the supermarket, places I'm in. So this is critical. We have spent the last several years, especially in TCPA and the overlap between TCPA and FDCPA, about consent and consent management. And that's been a huge thing. And I, continue to do that. But now, the way I read the rules, we have to do preference management. And that's complicated. And it's complicated if you have a large agency. You've got to, regardless of whether everybody's sitting at home or in a call center, calls are coming in. You don't have a lot of time to determine, okay, the consumer called last week and made a preference, said, I only want you to call me on Tuesdays between 2 and 3 at this particular number. And the consumer calls in, and if it's between Tuesdays between 2 and 4 as what their preference is, but they're calling in on Wednesdays, you got to make note that they had a preference. They called at a different time. I can't continue to call them on Wednesdays because they already told me Tuesday. I've got to reconfirm each time I'm speaking to a consumer to capture those preferences. That's going to take a long time.
It is.
Long time.
Before we move to Tom and Stephanie, I have some, I feel this is a passionate one for me, but
yeah.
Everybody agree, raise your, would you agree that we cannot call it a preference? And the reason is there are so many data analytics companies out there that are selling behavior and predictions and modeling and all kinds of stuff about, yeah, they like to answer the phone at 6:30, but that's because they work between. I mean, I consider this a restriction. If the consumer says, call me, it's not just a preference. It's not like it's just be nice for you to call me on Tuesday between 2 and 3. I think do we all, is that, I mean, for purposes of the listeners?
I think if the outcome is the same, I mean, you have to abide by their preferences. So if you want to call that as a restriction, that's fine. The bottom line is there's a whole new set of requirements that you have to capture and make your collectors know in an instant what that is at every given time. And that's going to be a challenge for a lot of people.
It will. Thank you. Tom?
I mean, preference is the wrong word, because what they're really doing is they're letting the consumer define for you what an inconvenient time is. For instance, if they say, I only want to be talked to on Tuesday between 2 and 3, they just defined 167 hours of the week as being an inconvenient time. You've got to follow that. Yeah. And the guy I thought about when I read this was, how would you like to be a dialer manager? Because you have to figure out a way for this customer who's one of 100,000 you're trying to collect from, that you cannot put him in any queue for a dialer campaign that isn't between 2 and 3 on Tuesday. And I don't know how you program that. And that's why I'm a lawyer, not a computer programmer. But that is that's an issue you're going to have to work with your vendors to figure out how they're going to program it. And good luck. Because what they've done is they've really taken a very simple concept that, don't call before 8, don't call after 9, and turned it into a very customer friendly, which isn't a bad thing, but it's a define the time you want to be contacted. And that's hard to manage in a volume practice.
It is. Stephanie?
Yeah, if I'm being completely honest with our listeners and my co-panelists, this is a section I'm still really bewildered by. And I think my reaction of saying, to your point, Tom, how in the world did we operationalize this is likely how everybody who's listening feels. So you're not alone and you're not missing something. The whole mechanism assumes that there will be some lengthy, productive, calm conversation with the consumer where you can flesh it all out. And my question is, well, what happens if you can't do that? Or even if you're lucky enough to do that, it's still not maybe as clear as you'd like, right? And you can't call them back necessarily, maybe, and get them to clarify. What do? Do you just have to stop? And I think courts are going to go different ways. And there's an analog for that. We already see the concept of partial revocation of consent, which is what this kind of is, in TCPA. And these struggles are already resulting in very different decisions from courts and arbitrators. And that is about to wholesale invade the FDCPA world as well as a result. So I'm very bewildered by it, to be honest with you.
And I have one last twist to this one. So now if you think about this, the consumers can dictate, basically define what is convenient for them, and as we've just discussed. Who also says is that if I'm the consumer and you're the debt collector, and I say you may call me on Fridays between 3 and 5, that's you. But you know what? I feel like calling my debt collector between 3 and 5 on Friday. I feel like that would be a great time to talk to that debt collector. rule says that, of course, the consumer can call you or reach out to you using any particular mode that you have available. If your website says email, if you've got a billboard out that says text or whatever, if they contact you using a particular mode of communication you make available during those restricted times, you may call them back, or you may return the communication to them once using the same mode that they just used to communicate with you, but it has to be on the same day. Talk about, isn't that just crazy? I think. I mean, we're dealing with it internally just in terms of trying to manage. How do you think through this as a coder? But right.
Well, it's one of the things, and I know that the Bureau does not accept this, but we've been talking about it since, I think, 2013 when the ANPRM came out. This is going to require this is going to cause an uptick in consumer litigation, because the consumer, and I'm not saying they shouldn't be in the driver's seat and be able to control communicate. I'm not saying one way or the other. It's not for me to do. What I am saying is that is definitely what the rule has done. And in some places, that's going to be very difficult to suss through. On top of that, the clock is ticking because we're going to have time bar debt coming out in December too.
Right.
And if you're a collection law firm, it's probably music to your ears what I'm saying right now, because I continue to believe and have consistently believed for years that you're about to have a lot of opportunity. But I also remember back, and I think others that are listening, thinking about, if you don't sue on debt, I don't know. But I'm suspicious of that, if that will remain a viable strategy in the future. But look back at the last economic crisis, the foreclosure crisis, where we had a huge increase in foreclosures, and when those needed to be done judicially, or even like in a state, Georgia, where I am, you can do them without court involvement. There's a counterclaim asserted by the borrower to try to stop that process. The courts were crushed. They couldn't keep up. There were major impacts of that took years to work through. I fear that that's about to happen to our state courts, small claim courts, et cetera. And I don't think they're prepared for that volume. So I know the Bureau doesn't accept this. Maybe I'll be wrong, but I can't get away from it.
Right. No, I agree. Before we jump into some very specifics about that lovely validation notice, I wanted to put a plug in for this, the Revolution, the series that you are participating in. And the plug is that what we have intentionally done is created a slot for one of our esteemed, well-respected defense lawyers to position and poise that person against a very renowned, successful, I'll say aggressive consumer lawyer. Because just as Stephanie was saying, this may just be the launch of a whole new wave of litigation. Later in the series, we are going to listen to how does the consumer bar react? What is their reaction to this? I suspect it's in terms of maybe a boat, a second edition on a car, on a house, maybe a cabin, but I mean, it may be lucrative. So that's just an aside, but I think it's cool that we're going to have that session. So I hope the listeners, I encourage you to listen to the session on, and I think maybe at the end, Mike or somebody can put it in the chat when it is. I don't really know off the top of my head, but anyway, it's a cool thing through the Revolution. So let's talk about that validation notice, because that's really, I mean, if you're not confused now as an audience listener, let's just try to help you sort through the validation notice. I think I'm going to go back to Joanne. Do you want to lay the groundwork for what the law already says about a validation notice? And then maybe we can start to leap from there.
Well, right now we just have the act.
Right.
As far as the validation notice, and everybody knows what the validation notice is. It's a poorly drafted section of the FDCPA, which doesn't necessarily, it says you have to, identify the debt, doesn't say anything about itemization, interest, or anything. It says you have to identify the creditor, doesn't talk about successive, whether there's been a chain of title. So it's been certainly a source of heartburn for the entire industry since 1977. And, through all the years of all of us having engagement with regulators, the line has always been, tell us what you want to say. Tell us what it is, and we'll do whatever you tell us to do. I was really hoping when the final rule came out, we would have clarity on that. And the Bureau did not finalize the validation notice or the aspects of dispute or information about original creditors, things like that, all the things you can put in the validation notice, and the time bar debt disclosures.
Right.
They are calling it a disclosure-focused final rule, which will be published in December. Hopefully.
Good. Very good.
They need because they need more quantitative testing.
Sure.
All of us have been following the Bureau for many, many years. I've never known them to do quantitative testing in 2 months. So,
Roseanne,
Stephanie, what about I'm sorry, go ahead, Mike.
I'm sorry to interrupt. I just wanted to say the plaintiffs and defense attorney discussion table that you referenced is scheduled for next Thursday, the 12th at 11:30. And we'll make sure everybody knows about that as well. But I just wanted to make sure you knew.
Thank you. Eastern time, Eastern.
Is there another time?
There is. Anyway, there's the frozen tundra out here in Minnesota. Stephanie, and then to Tom, do you want to talk about I think some people actually have had this, like a moment, like an aha moment at a time. I thought most people understood this, but what about the difference between how you may deliver a validation notice if it is the initial communication versus well, I'll just leave it at that. You know what I'm getting at. You want to explain the rule and the way it exists now?
Stephanie, you want to take that or take the first shot at that?
Yes, because it is actually, in addition to the election results, been keeping me up at night this week, and I've given it a lot of thought. So I'd be happy to. It's interesting, right? Because one of the things that collectors are very excited about, or at least said they seem to be excited about, is the opportunity to save the mailing costs on the validation notice and use email. So the Bureau, let's start that the Bureau has most definitely required in section 42 of the new rule that if you are going to send the validation notice by email, you have to have e-sign compliance with a single exception. If the sending of the validation notice in like the body of an email is your initial communication with the consumer. So that's a place where, to our earlier discussion, communication means all channels of contact, or at least I'm not going to tell you differently until some court says you can limit it more. So no calls, no texts, no welcome letters. Those are all communications that would, as I read the rule, risk invalidating this one little tiny opportunity and instead require e-sign compliance. However, if you have the creditor who comply with the email consent transfer provisions in section 6D, with, as we talked about earlier, the 35-day notice and the specific disclosure of the debt collector, et cetera. And then once that's cleared, the consumer has not opted out, and you send the email with the validation notice in the body, a safe harbor, it's section 22G, would allow that to, if it results in an inadvertent third-party disclosure, not be a violation of the FDCPA. But it is an incredibly limited opportunity. And one of the things I was discussing actually with Roseanne and Joanne earlier today in connection with something else is what happens if that email bounces back? Well, I think at that point, you may have lost your ability to put it in your initial communication. I don't think your 5-day, I don't think you've had a right party contact, so I think you can just wait. But the next time you get in touch with that consumer, I think if you still want to use email, e-sign probably comes back into play.
Right. Tom, I'm going to turn this to you for your comment. Thank you. Thank you very much. Just as a reminder, since 1977, the rule is clearly stated with regard to the validation notice in the FDCPA. You must provide the following information. Then it goes through the validation notice, the requirements Joanne referenced. It's kind of in a cryptic way, but anyway, if during your initial communication you provide this information, you may provide this information, the validation notice, but if you don't provide it in the initial communication, you shall provide it within 5 days thereof.
Mm-hmm.
That's where you have to send it.
Right.
Writing. That's where the writing requirement kicks in. So that's the what everyone has to realize, when you're analyzing what you want to do, what Stephanie talked about is the new requirements for email may help you very much, but that's in the initial communication phase of the analysis. Tom?
Yeah, look at the email communication is a real benefit, but people have to be very careful because there's some landmines to step in that you can step into. There is a human tendency to want to make the validation notice something that it isn't. And, people want to have a friendly, great opportunity type heading to the email to cause people to open it. The rule is very specific in terms of what information has to be in the subject line of the email for it to be effective. Secondly, and there is an opportunity, and maybe I'm misreading it, and I concede that as a possibility in any 650-page document, but they make reference to the fact that they want this notice delivered in a way that the person can reference it. They can save a copy, and they can presumably print it off and things like that. There is a technical ability in the FDCPA itself to give a verbal notice. Did that just go away, do you think?
I don't think so.
I don't think so.
Go ahead.
Yeah, I don't think so, because in reading the commentary around it, the Bureau's acknowledging that. And if we all recall the Green versus True Accord case from last year out of the Northern District of California, that was one of the reasoning that the court was thinking about in refusing to require e-sign compliance there. But what I think the practical reality of the things you're rightfully pointing out, Tom, is that we may not see an immediate or massive shift to email delivery of legally required notices. I think we may stay put in the more 1977 world of sending a letter and then seeing where our later collection communications, which are easier to have by email, it's a lesser level of consent, take us, at least for now.
It seems to me that if you want to do a validation notice by email, then you're kind of roped into, boy, I hope my creditor client did what they needed to do to get me the email address, and they sent out the notice and the opt-out right. Or I'm relying on a prior or the immediately prior collection agency. I'm not sure I like either one of those for the delivery of a legally required document. And that's
Would you guys agree? Would you agree that this final rule just killed the pass-through consent that so many collectors have been relying on in a very casual way for both mobile numbers and email? What do you guys think about that, Joanne?
I think so. I think so, because the risk is just too great. The risk is way, way too great. I agree. Tom makes a really interesting point, and his partner was on a webinar yesterday and
which is true every day.
Right. On this subject of email and text and delivering notices. And he said, is it a rule or is it a change in the law? Mm-hmm. And I think that is a concept that we have to think about. Rules are about interpreting statutes. The FDCPA doesn't say anything about email and text, nothing. Now, you want to call an email a writing, you want to call a text a call, we can have that discussion. But, and not that I don't disagree with the Bureau putting out rules about email and text. We've got to move forward. But remember, the FDCPA, as we've talked about, all I got to do is send the letter. Doesn't even, unless it comes back, clearly, unknown delivery or move, no forwarding address. Okay, fine. That's the only requirement in the FDCPA to confirm information. And now all of a sudden with email, there's this heightened, you got to make sure there's notice, they got to make sure they can print it out. That's not anywhere in the statute. Do I think it should be, or should it be in the rule? That's fine. But that's, I think, where where I think there's going to be a lot of discussion about how these rules move forward, especially with consumer advocates, because consumer advocates are not really crazy that we're doing electronic communication to consumers. And that's going to be an issue with them.
One of the things that I know my partner, the litigator, tends to think about is, well, is it possible that a new administration could pull this rule? Mm-hmm. And I don't think they'll pull all of it, but I think this is an area that they're going to circle and really seriously evaluate, because, you know, consumer advocates want consumers to be able to communicate with debt collectors by email and by text and things like that if they choose. But I don't think they want it both ways on this one.
No, I don't. So I think that's going to be, it's going to be an interesting issue, and yet another area where we're going to have to monitor. You talk about restrictions, you talk about preferences, however you want to define them. Another area where you're going to have to keep track of all of that.
And
You
this
know
is
what
a
is
hard operational issue too, because how are you going to send out the emails? Are you going to open up debt collector or your individual collectors to have the ability to email an individual consumer? And if so, how do you lock down the content?
Right.
I wouldn't do so. Do you know what I think is, this is too much of my personality, but it's just, I think A, stupid, and B, obnoxious about these rules, is the fact that, under the cease and desist provision, if it provides, a statement that they refuse to pay or request that you cease and desist communication, but in writing, they honor that. I mean, that's kind of the way the law, more or less. Anyway, but under the final rule, they said, you know what, it's close enough. If the consumer wants to just email that or use, some communication, it's close enough to e-sign. The debt collector's got an email address. Let's just let them email cease and desist now. Does anybody else feel as kind of, I don't know, Tom, you look like you kind of.
Yeah, that raises a real, it's a quick operational fix, but you need to do it. And that is, you cannot have any of these emails on your website be unattended.
Right.
You cannot have the fax machine in the corner that nobody looks at for a month. I know I got burned on that at a prior company, that there was a fax machine that no one really was responsible for, and somebody found out about it and kept sending cease and desists to that fax machine and then suing us. Right. So you just have to be very careful that you don't have any publicly available communication means that you don't have a responsible person for.
Right. Exactly. Another comment or another topic I'd like our panelists here to address would be, there's been a change in document retention requirements. And this, I think, has a significant operational impact on our audience. Anybody up for grabs if anyone wants to take this one first?
Well, it's interesting because I had occasion to look at state retention requirements for a client a few months ago, and most states, not all, but many are 3 years or less, but 2 or 3, a few are 4, 5, and 6, most notably like New York City, for instance, except for calls, which are 1 year. But in doing that, there was a lot of ambiguity, right? But I also realized that I could make arguments and did for the client that these are really restricted and it doesn't cover all your collection stuff, again, with a few exceptions, like New York City and a few others. This rule, I think, really just undid a lot of that. I think it really broadened what you have to keep for 3 years. At least they're being direct about how you calculate those time periods for collection information and call recordings. Call recordings are just one from the year of the date of the call recording, the communication, I should say, the call. But it's a lot, and it's going to be expensive, I think, for many companies, and it's going to be different than what their current retention looks like, because some, regardless of whether it's a best practice to keep call recordings for longer than, say, a month or 2, some continue to, that's really all they can manage because of volume and afford. And also these state laws that often arise under state licensing requirements, not always, but often, you may have an understanding of, okay, well, this is in, but this is not. It may be specific enough for you. That just went away. I mean, it's really broad.
I think so too.
And I worry about the computer, or not computer, but the technological storage that you're going to have in order to retain all the recordings that you're going to have to keep. And under their very last comment in the entire rules is that if you if you record calls, and they're saying you don't have to, but if you do, you must retain the recording of each such telephone call for 3 years after the date of the call. Wow, that's a lot of computer storage. And
what happens if there's the 3 years has passed?
Yeah.
And then a year later, the consumer calls and says, "Oh, I'm buying a house, and I thought you were supposed to satisfy my judgment," and that's called. So it's every call you got to keep doing it. I think there's a lot of technology companies that are talking about this and putting plans together. I think it's indefinite. I mean, it really is. I mean, do collection cases ever really die? No, they always come back to life somewhere. So it's hard to say there's an end date. I just don't think it's possible to calculate an end date.
Well, I agree. And from a technology standpoint, this is a stumper question that crossed my desk several years ago. And it relates to this topic of document retention. A lot of collection agencies tie accounts, or they packet accounts. So they'll have a lead account that they're calling on, but they will have tied to that 3 or 4 other accounts. So the new rule with document retention, maybe everybody knows the answer to this, but what perplexes me, what could mushroom the volume of documentation that needs to be retained is that if I call you on account A and I talk about B, C, and D, now, because everything is per account, do I have to duplicate and save everything in 4 different tranches? If you know what I mean? Don't you think that's the case now?
I do think that's absolutely the case.
Yeah.
And you know what? If it's not the case, it should be the case, because I think the whole point of document retention is to do the look back. And if there's an account tied to another account, how are you going to do the look back, and how are you going to do it carefully? So I agree.
Right.
It gets back to my first point. You're going to survive under these rules if you take a conservative view and don't try to get right to the line. And, so if you're approaching a question, geez, do I have to keep this one for 3 years and this one for 3 years? The answer is yes. Because the consequences of guessing wrong are too big.
Right. Yes, Mike. Hi.
I'm watching the clock here. A number of our subject matter experts are going to be exiting very, very shortly for other obligations. They've given us a lot of quality time today. I think it's critical that we go around the horn before they do. Just as a parting shot, 30 seconds or less, or a minute. What do they want to leave our audience thinking about? Stephanie should start, because I know she needs to leave, and then Tom should go second, because I know he has all exactly.
Thank you. Good suggestion.
Well, and thank you.
As we wrap up this session, you all have been fabulous. I can't thank you enough for your contributions. Before we wrap it up, let's just have a parting comment from each of you. What are your observations? What are your recommendations? What do you think our audience needs to hear from you? Stephanie, if you'd like to start.
Yeah, and first I just wanted to thank Mike, Roseanne, and the rest of the panel. I've really thought this was a great discussion and enjoyed being a part of it. So thank you for the invitation to do so. And I hope our listeners feel similarly. I think Tom really actually stole my thunder. I totally agree. Compliance and survival here, and making the rule work for you, I think means we have to start from perhaps a more conservative position than we want, to start figuring out what works, what doesn't, and what risks we're willing to take on. And then I assure you that there will be entities that are willing to take on different risks at different times. And I think the industry needs to remain focused on trying as best as it can to create good case law. That means being intentional about the cases we pursue and the ones we don't, being thoughtful about how we evolve the interpretations and implementation of the new rule. And I think at the end, that is likely to result in an environment that is beneficial both for the industry and consumers, which is ultimately what I do believe the Bureau is trying to achieve.
Thank you. That's excellent. And thank you so much. You were great. Appreciate it. Tom?
As with Stephanie, I've learned more from listening to you, the rest of the panel, than actually by speaking. I would suggest very strongly that you if I'm a manager of an agency or an owner of an agency, I need to sit back in my chair and I need to say, how do I currently use my computer systems to manage compliance? And then you're going to have to say, I'm going to have to amplify that, and I'm going to have to figure out how it works in this current rule environment. Especially think about your dialer. Think about how you manage your call flow in a world where we've got the 7 attempt limits and only one conversation, and I only want to be talked to on Tuesday at 2. How are you going to manage that? And I think that's going to actually take the most time of anything you have to do as an owner.
Thank you, Tom. Excellent. We really enjoyed your participation, and we all learned from you as well, believe me. Joanne, let's wrap it up with you. You always have something great to say.
Well, thank you. And thank you, Mike, very much for putting this together, and my panelists. It was always a pleasure, always a pleasure. 2 things I want to say. First of all, as we mentioned, the validation notice, their disclosure focus rules not coming out till December, which made putting out this rule a little bit complicated because debt collection is a process, has a beginning, a middle, and then we never know really what it's going to end. And we don't have the beginning part of the process yet. We only have kind of the middle. So I would use this next 2 months, following up on what both Stephanie and Tom said. I think you got to really read it. You got to see where your gaps are. You got to see how your operations can align with what is being proposed. I do think there's a lot of technology opportunities here. And I think you really need to look at that and see, you know, how can I work with my vendors to improve? There's going to have to be a lot of systemic changes because we love our collectors, but there's only so much our collectors can do. And I think
Absolutely.
Yeah. So I mean, I think that's what you need to do for the next 2 months. I would love to come back with you all because I want to hear your perspective. I think once we get the model validation notice, that is going to change a lot. And I think it's also going to change how we communicate with consumers, because my sense in reading the rule is the more we can drive consumers to us, it's easier said than done, but the more that we can do that, all these restrictions and preferences and consents are going to be a lot easier to manage. So thank you.
That's a great statement. Thank you, Joanne. Thank you, everyone. My only comment is read the rule. You don't read all 650, but read the rule. It is the best thing you can do. Why don't you do it right now after this session? Thank you. We appreciate it very much. Thank you.
Thank you.
Hello again. That was a wonderful roundtable, wasn't it? I learned a lot from our wonderful speakers, and I'm sure you did too. Before we finish, I want to quickly go over Q&A. If you asked a question in chat and hasn't been answered already, don't worry, you'll receive a response within 24 hours through email or another similar channel from one of our SMEs. In addition, I highly encourage you to connect with our speakers through the platform. They're extremely knowledgeable and they're super excited to share their knowledge with you. So I definitely encourage that. And feel free to reach out to us too, and to Mike, because I'm sure he'd love to talk with you as well. So once again, thank you for attending the Business Revolution Week, and I hope you have a wonderful day. Thank you.